Good morning. I'm Alan Fields, principal at Kenai Central High School. On behalf of our school and the Kenai Peninsula Borough School District, I want to welcome all of you to this first Supreme Court Live on the peninsula. This program's been in place for a while, but it's their first time here, and Kenai Central High School is very pleased to host, and I want to thank all of you for showing up. I want to thank all of the teachers for working with all of their students and all of our local attorneys for coming into the classroom to share your expertise with everyone. Thank you and enjoy the program.
Good morning, everybody. My name is Craig Stowers. I'm the Chief Justice of the Alaska Supreme Court, and I want to thank you all for being here. I want to thank you all for inviting us, the Supreme Court, to come and do this program with you today. We do a lot of things on the Supreme Court and the court system in general to reach out to the public, to try to help people understand what the courts do, to try to get the public to participate, and that could run the gamut from serving on juries to volunteering in certain programs. But of all the things we do, Supreme Court Live, coming to schools like this and sort of sharing a morning with you, is one of the favorite things that we do. This program is really all for you. It's not all about you. You'll hear the case that's going to be argued this morning, but it gives you a chance, as you already know, because I think most of you work through the materials with the volunteer attorneys in your schools. You know a little bit about the case. You've studied the process that brings a case through the courts, first the trial courts and then ultimately to the Supreme Court. And I'm just really thrilled that you get a chance to participate in this. You know, sometimes, when I'm talking to parents, other lawyers, they say, I'm not sure that our kids get it. I'm not sure that they understand what this is all about. And I just disagree. I think that you folks really do get it. You have access to more information about the world and about government and about courts if you choose to access it. And I really encourage you to do that. So I'm going to stop now. We're going to start the argument in a few minutes. I just want to remind you that for the next hour or so, this is not an auditorium. This is a courtroom. And the lawyers treat it that way. I want to take a moment to thank the lawyers for being willing to come and do this. It's hard enough, believe me, because I used to do this before I was a judge, arguing cases in a courtroom before a judge or before the Supreme Court. And it takes a special kind of courage and willingness to be able to come and do this in front of a bunch of students and teachers and the public. And so I really thank all of you for being willing to do this and for your service. So after we're done, as you know, you're going to get a chance to talk to and ask questions of the lawyers. And then after that's finished, you'll get a chance to ask the Supreme Court some questions, and then we'll be done. And I'll thank everybody else who's made this such a worthwhile effort at the end of the program. So thank you very much, and I'll see you in a minute. Good morning, everybody. This is the time set for oral argument in the appeal State of Alaska versus Alaska Democratic Party. Counsel, are you ready? Ms. Fox.
Good morning, and may it please the court. My name is Laura Fox, and I represent the state of Alaska. The challenge law says that to run for office under a political party's label, a candidate must adopt that political party's label. The court should uphold this sensible and easy to satisfy component of Alaska's election system. The party affiliation rule represents a policy choice by the Alaska legislature, and it's entitled to a presumption of constitutionality. So the court should not lightly strike it down, even though it touches on associational rights. In the elections context, associational rights are always in play, but the state needs to be able to run elections, and that means it needs a system with rules and structure and some leeway to operate. So keeping this in mind, the court applies a flexible balancing test when it's assessing a challenge to an election law. On the one side of the balance, the court looks at whether a law burdens associational rights and how severe the burden is. And on the other side of the balance, the court looks at the state interests that justify the law, assessing their strength and their relationship to the law. And here we have a law that creates a minimal burden and is justified as an integral part of the state's election system. So first I want to discuss the law's minimal burden on associational rights, and then I want to discuss on the other side of the balance the state interests that justify the law. The party affiliation rule doesn't severely burden associational rights because it does not prevent anybody from associating if they want to. A candidate who wants to run under a political party's label must simply adopt the party's label, which is easy to do and not much to ask. And a party who wants to nominate a candidate to run under its label must simply convince the candidate to take this easy step. And any group of people who want to nominate a candidate who refuses to adopt a party label can use the petition process instead to nominate the candidate. So all associations are possible under the state system. And although a party can't nominate a person who refuses to adopt its label, a party's ability to nominate a particular person as its candidate is always going to be constrained by that candidate's choices. The party can't nominate a person who refuses to run in its primary, even if it thinks that person's the best candidate. And it can't nominate a person who doesn't timely file a declaration of candidacy, or a person who doesn't meet the qualifications for the office. So these kinds of things all shrink the universe of potential candidates that a party can nominate, but they're not severe burdens on a party's associational rights. And federal courts agree that candidate eligibility rules, like the party affiliation rule, don't create severe burdens on associational rights. So in the briefing, the state discussed 3 types of cases that are candidate eligibility cases. And those are anti-fusion, sore loser, and affiliation and disaffiliation cases. And in all of those cases, the party's universe of potential candidates is restricted by a rule, but the courts nonetheless don't consider that to be a severe burden on associational rights. And so I'll briefly touch on each of those 3 kinds of cases. So first,
Let me ask you a question, if I could. Doesn't it make a difference that in Alaska we place a very high premium on independent voters? There are more independent or non-affiliated or nonpartisan voters in this state than almost every other state in the country. There might be one that has more. But isn't that a difference that's worth noting? And doesn't that distinguish Alaska from all of these other cases, whether you're talking about sore loser cases or fusion cases or anything like that?
Alaska still has a partisan primary system, though, and there's a system in place for independent candidates and candidates who don't want to affiliate with a particular party, and that's what the petition process is for those candidates.
Yeah, but this is the party that wants, it's not that someone is trying to, from the outside, force the party to accept an independent individual who wants to run as a candidate. This is the party itself that wants to be able to do this.
Well, the party can, so independent is just a category that's defined by the desire to distance oneself from a party. It's not an ideology in and of itself. It's not a particular set of views. I mean, certainly independent candidates could hold any variety of different kinds of views, but the category independent is defined just by the desire not to associate with a particular party. And so a party can certainly change its platform, change its views in any way to appeal to any set of voters, independent or otherwise, or any set of candidates that it might want to persuade to join up with it. But the and the party, sorry.
Go ahead. So, well, let me follow up then on a question. You know, the reality is in Alaska that the majority of voters are non-affiliated, nonpartisan, or independent. And there are other parties that used to occupy a position where they might have claimed a majority of the voters, but now they don't. And politics is power, in one sense. And so you have a party that doesn't have as much power in terms of people who are willing to sign on and become members of that party, but it still wants to be relevant. And so what it needs to do to be relevant is be able to attract other voters to participate in it. But these voters may not want to sign on the dotted line and say, I want to be a member, but they may be willing to support some, but not necessarily all of the ideology or the platform that the party puts forward. So if the party wants to expand its opportunity to reach a larger body of people and to maintain its power or regain its power, what's wrong with this idea from a legal point of view of letting the party do exactly that? It may be a bad idea. I mean, I can think of a situation where you might have a rogue person who at one point was a member of one party and then became an independent or joined another party and came in and took over the party, but that's a different story. But what's wrong with the party doing this? Well,
there's nothing wrong with the party wanting to do this, but association is a two-way street. So it's sort of like in the anti-fusion cases, you have a party that wants to nominate the same candidate as another party wants to nominate, and there might be strategic reasons the party might want to do that. They might want to sort of, join up with this other party in nominating the same candidate, but the courts nonetheless looked at that and said, well, the party's associational right, associational interest in associating with that particular candidate that another party is nominating is reduced because that candidate is just prioritizing basically the other party. That candidate is prioritizing their desire to associate with this other party over this, the one party. And so...
But isn't that a significant difference? That they already sort of belong to this other party?
Well, it's the same thing here. A candidate who refuses to register with the party is prioritizing his or her desire to distance themselves from the party over the desire to associate with it, because registering with the party is a very easy step for the candidate and not a lot to ask of somebody who is supposedly going to be representing that party and running under that party's label and presenting themselves to the voters as the representative of that party. And a candidate who refuses to do that is saying, I'm prioritizing my desire to distance myself from this party over my desire to associate with it. And that reduces the strength of the party's associational interest. And it's not that the party has no associational interest in play or no associational interest in associating with that person. It's just it's reduced by that candidate's choice. And so that's what makes it a lesser burden and not a severe burden on the party's associational rights.
But I think that gets back to the Chief Justice's question of why does the state care, right? Even if this could be a self-destructive policy for the Democratic Party, but if they've chosen to do that, why not let them self-destruct?
So that gets to the other side of the constitutional balance, which is about the state interests justifying the law, and I can move on to that if you would like. But I was first getting at the reduced strength of the party's associational interest here, and why which is why this is a less severe burden. But I can certainly turn to the state interests.
I'm not trying to disrupt you.
Oh.
Well, let me ask a question about the burden before you move on. Is there any mechanism by which a party could decline to hold a primary, assuming that it has several members who qualify as primary candidates, but the party as a party decides that it actually wants to petition to have a different candidate appear on the ballot and declines to hold a primary? Does that work under Alaska state law?
Well, any group of voters whether they're party members or not party members, can join together to petition to nominate a candidate that way.
Can an established party decide, oh, we're not going to have a primary this year, even though we have several candidates who qualify to be primary candidates?
No, I mean, the system is set up so that a party that's gotten official recognition chooses its candidates through a primary, which is
So they
what
can't-
most states did. It's been a long-standing system that states have sort of mandatory direct primaries for the recognized parties.
So essentially, if they wanted to back a candidate by petition, they would still have to go through the primary process and have a candidate on the general ballot with a D by that candidate's name.
Well, the party, I mean, it's maybe worthwhile to think a little bit about who the party is. I mean, there's the party leadership, and then there's all of the voters who have self-identified with the party. And so, I mean, any group of voters, again, who wants to nominate a particular candidate can do that by petition, but the primary process is set up as the way for an established party to nominate its established party candidate.
Let me ask you a quick question, and then I'll let you go, okay? Let's say hypothetically that you have an individual, Jane Smith, and Jane has been an independent, nonpartisan for years and years, but then she decides because she wants to run for office and the Democratic Party is willing to have her run to be a candidate under the Democratic Party umbrella. She, right before the primary election, signs on the dotted line and says, I'm going to run as a Democrat. That's legal, right?
It registers as a Democrat right before the primary.
Right.
Yes.
Right. Okay, so now she runs in the primary as a Democrat, and she wins, and then she immediately unsigns and says, now I'm a nonpartisan again. Is that legal?
I think that would be a statutory interpretation question that it hasn't come up yet, so I don't want to. I mean, you could look at the statutes
But
don't
you
appear
must
to be
answer the
written to
question.
specific. Sorry.
You must answer the question.
Yeah, the statutes aren't written with that sort of to specifically contemplate that. I think arguably that since that's one of the things.
Well, the statute doesn't say you can't do that.
That's true, and also so
So if that's true, if that would be perfectly lawful, that she signs, she becomes a Democrat for a day, she wins the election, and then she unsigns and says, okay, I'm not a Democrat anymore, I'm a nonpartisan, and that's legal. What difference does it make?
Well, I think the fact that the law can be circumvented or that it's not perfect doesn't mean that it's not useful. And also, I mean, I think that such a person, by having to take those steps, that would all be apparent to voters. It would be, the way in which that they're circumventing the law. But it's still reasonable for the state to draw a distinction between people who are willing to identify with the party publicly and people who aren't. I mean, certainly somebody can register with the party and still say that they don't really believe in the party's principles, or they can not really believe in the party's principles, but it's still reasonable to distinguish between people
Now
who
you're
are...
getting into interests and not the associational. Right, now you're getting into interests.
Right, and I think that question seemed to me to go more towards the state interest than
Right.
the burden half. So, I would like, given the time, I would like to move on to state interest.
I have a question for you about interests. I would like to hear you articulate the government's interest in a stable election process.
So,
How is it that this could destabilize the election process?
Alaska's election system is designed around political parties and gives them a special role to play in the process. So parties are defined to be an organized group of voters that represents a political program and that's achieved a certain amount of support. And so the state-run primary election is meant to be a way for the group of voters that represent the Democratic Party, that all the people who are willing to say, yes, I'm a Democrat and that's the political program that I support, to choose a candidate to represent those views. And the system Alaska's system provides an alternative path, the petition process, for people who don't want to do that, who don't want to say identify with a particular party. And here what the Democratic Party essentially wants is to have a primary in which anyone can vote and anyone can run without the need to publicly support the Democratic Party's platform. But there's a name for primary.
We already have a system where anybody can vote, right?
Right, and so
that's out of the equation.
But if you take that and you take away the other half of that, so now it's not just one that anyone can vote. Anyone can vote and anyone can run, and that's essentially a nonpartisan primary. That's what a primary where anyone can vote and anyone can run is a nonpartisan primary. And some states hold nonpartisan primaries, but the Alaska legislature has chosen, like many other states, a partisan primary system, which is designed around the idea that voters with similar views will group together to nominate people that also support those similar views. And this system only makes sense if there's at least some minimal connection between the party's candidate and the nominating party's views, which can be as simple as what Alaska has here is the candidate just has to be somebody who says, I support those views. And it's reasonable to distinguish between people who are willing to say that and people who are not. And if a party's nominee can be a non-member who's chosen by non-members, the party's nomination no longer has any connection to the party's views, and the partisan primary system loses its coherence as a partisan primary system. And so what the party's primary becomes is akin to a mini nonpartisan primary instead of a partisan primary, and then the party's nomination no longer reveals anything about the candidate's views, and so the party's label becomes less useful as a signal to voters, and the foundation of the system as it's been set up is undermined because it makes no sense to hold partisan primaries if candidates can have no connection to their nominating parties. And the state could just have a blanket nonpartisan primary instead, which is what some states have, but that's not the policy choice that the Alaska legislature made, and it's within the legislature's purview to choose a partisan primary system. And so that's why the party affiliation rule helps preserve political stability and the coherence of Alaska's election system. So the state also has two somewhat more concrete interests at issue, and those are the interest in ensuring that candidates and parties have a sufficient modicum of support to merit party status and a place on the ballot, and then the other one was the interest in preventing voter confusion and deception at the polls. And so I'll just briefly, if I can, touch on both of those. So removing the connection between the party's candidate and the party's views messes up the system that the state uses to determine recognize party status and to give candidates places on the ballot. So the court has recognized the state's interest in ensuring that only serious candidates get on the general election ballot and that political party status is reserved for groups with sufficient public support. And the state uses this proxy system for doing that. And under that system, votes for a candidate...
Why wasn't the Superior Court exactly right in saying that it made no sense to make this argument about the primary election when the support is evaluated in the general election on a statewide basis for, statewide and nationwide elections?
Well, the Superior Court did not look at both halves of the state's argument. So this proxy system works both ways. So it's the party recognition and then also candidate support. And so a political party votes for a candidate in the general election are considered to represent public support for the party that nominated the candidate. So the party gets official recognition based on how many votes its nominee gets in the general election. And so in other words, if a lot of people are voting for a candidate who is supporting the party's views, that shows that a lot of people support the party's views, so the party should get official recognition. But if you take away the connection between the candidate and the party's views, the party can nominate somebody who's distancing themselves from the party's views, who doesn't purport to share the party's views, then votes for that candidate represent support for that candidate in the general election, but not support for the nominating party. So it makes no sense anymore to have that connection between votes for the candidate and the party's official recognition status. And so the Superior Court only looked at the flip side of that, which is about making sure the candidates have sufficient support before they get on the ballot. The Superior Court sort of brushed aside the party recognition part because it said, well, the Democratic Party's not anywhere near that threshold. But, we're looking at this in general, not just as applied to the Democratic Party. So the system needs to make sense for all parties. But removing the party affiliation rule also messes up the flip side of this for candidates, because the public support for a recognized party is imputed to the party's nominee, and that's how the party's nominee gets on the general election ballot, sort of piggybacking off the party's public support. But if if candidate's not connected to the party's views, is not subscribing to the party's views, then that part of the system doesn't make sense either. So I just want to, very quickly.
I think you're right at 20 minutes by my watch. According to the timers, it's -2. Is that -2 beyond 20 minutes, or is that minus? Yes, they're nodding. So you were well over your total time, I think. So
No, I think that's over the time
25.
that I
Thank
had
you.
for the
All right.
opening. So
Well-
I'm going into my rebuttal.
okay, so you've got 3 minutes left.
I suppose I just wanted to briefly on the voter confusion, the ballot design thing. General election ballot featuring purportedly nonpartisan party nominees is either confusing or deceptive. It's either confusing because either you list, a word like nonpartisan or non-affiliated, and then the words Democratic Party nominee, which are inherently contradictory.
Why are they contradictory?
Because, the word nonpartisan means not affiliated with the party, not, and a party's nominee is inherently a partisan thing.
But that's circular, right? If the Democratic Party says, well, now we want to nominate you, even though you haven't signed on the dotted line, you don't think that a voter can look at that?
Well, the point of
Figure it
a party nominee is a partisan thing. And, putting the word nonpartisan next to that, it's inherently contradictory.
Put independent.
Well, the word independent is also contradictory because, the candidate's gotten on the general election ballot by riding the party's coattails. The candidate is dependent on the party. And so there's either a contradiction, or you can take out that word, but then you just have Democratic Party nominee, and people are going to assume that that's a Democrat, and that's going to be deceptive. So I would, if the court can think of a ballot design that it thinks isn't deceptive, it should, the state respectfully request that the court make clear what design that is, because otherwise the constitutional ruling striking down the party affiliation
So you
will
really
be
don't think that
incomplete.
division elections, all the people there can't possibly think of a ballot that wouldn't be deceptive?
No,
You don't think those people can do it?
well, the state's position is that all of these potential options are either confusing or deceptive. They're all problematic in some way. And if the state's wrong about that, if the court thinks the state's wrong about that, the court should clarify, what design the court thinks is not problematic.
You want us to design the ballot?
Well, the constitutional ruling is incomplete otherwise. If the ruling is that the state's law is unconstitutional because the ballot could be redesigned, that ruling is incomplete without an indication of what that design should look like. And I would, if I had any time left for rebuttal, I really would like to reserve it, so.
If you have any time left, you may.
Thank you, Your Honor.
You're welcome. Thank you, Ms. Fox. Joe.
Mr. Chief Justice, may it please the court. My name is John Choate, and I represent the Alaska Democratic Party. But the issue we address here today goes beyond just the Alaska Democratic Party and potentially affects all political parties in Alaska, the 3 recognized political parties there are now, plus any political parties that we may have in the future. It affects the 54% of voters in Alaska who choose not to register as a member of a political party, and it affects all Alaskans who live with the decisions made by the officials who are elected through our democratic process. And what I heard listening to Ms. Fox's argument is something that I saw when I was reviewing the state's briefs in the trial court and the state's briefs to this court, is that underpinning the state's argument is that the label by the candidate's name, that as she put it, or maybe the court put it, signing the dotted line, that is a proxy for ideology. It's a proxy for what that candidate believes. And the state is asserting an interest in filtering who may participate as a candidate based on what they believe, based upon their views. And
Don't you think that that pushes the state's argument a little bit far, though? What they're wanting is they're wanting the potential candidate to at least embrace the party. And the party has many, many ideologies. And I'm not talking about just the Democratic Party. That happens to be true of the Democratic Party, but it can be any party. They just want to make sure, the state wants to make sure that the person who is going to be running to be a leader in that party, perhaps the leader of that party, is showing some skin in the game in order to sign on and embrace the party itself.
I disagree, Your Honor. May I explain why?
Of course.
There is skin in the game. By choosing to associate with the party, even if you're not signing the dotted line and registering to vote as a member of that party, the candidate is going to be associated with the party, literally, on that ballot.
I agree with you, and so my question to her will be the question to you. What difference does it make? If they're going to be associated with the party, what's the burden of requiring them to sign on the dotted line, especially if they can unsign as soon as the election is over?
Because the identity does matter. The identity is important. But I think that the party and the people who make up the party and the candidates, the importance to them is not mirrored from the state's point of view. And what I mean by that is that just because it's important to the individual and as an independent to say, I am not a member of this party, I share some of its views, I support some of these things, but I don't agree with it on this, or I really don't like its executive leadership, or I don't like this official or this elected officer who is a member of this party and I don't stand for the same things as them, but I lean more towards them than I do to the other side. Their interest in associating together, the party's interest and that candidate's interest, just because that is strong, just because they have an interest in that person maintaining their identity as an independent, that doesn't mean that the state has a corresponding interest in of the same weight in governing that relationship. Because what the state is doing is saying, because your point of view is I'm an independent who is going to associate with the Democratic Party and try to be its nominee, but by retaining my identity as an independent, if we were talking about another speech restriction, that would be viewpoint discrimination. Because your point of view is I want to be an independent, but I share some beliefs with the Democratic Party and I want to represent them, that would be viewpoint discrimination, and viewpoint discrimination always gets strict scrutiny. In the associational context, when you govern the associational relationship, when the government puts restrictions on the associational relationship on the basis of identity, on the basis of beliefs, even if you can, in theory, as a person, cure that by signing the dotted line, I think that's the same thing as viewpoint discrimination in other contexts. There's a play by Arthur Miller, The Crucible, and it's about the Salem witch trials. And the main character is given the opportunity to avoid being executed if he admits to essentially having been involved with witchcraft. If he admits it, he'll be pardoned. And he refuses, knowing that he will be hanged as a witch, essentially. And in explaining his refusal, he says, the only thing I have is my name. And I think that's what's important here, is that there are 54% of Alaskans who may support one party or the other in many ways, who may want that opportunity to run for elected office. And the state Senate's argument that the system's designed around political parties, it's designed to give them certain advantages. But these people, if they want to retain their identity, if they won't want to say, I'm a Democrat, I'm a Republican, but they want to work together with them to get elected into office, they can't do that. They can't do that unless they give up their name, unless they give up their identity. And Alaska is a unique state. It is full of people who are independent, not just politically, but in the way they lead their lives. And our Constitution reflects this. I believe our Constitution is the most protective of any state's Constitution when it comes to individual liberties. And when this court said that that Constitution protects the right of political parties to decide for themselves who will participate in crystallizing their political positions into acceptable candidates, when this court said that, that reflected how protective our Constitution is of these rights. And when the state says, we're going to interfere on the basis of your name, on the basis of your identity, on the basis of who you are, even if you can fudge it, even if you can just sign the dotted line and, as Your Honor put forth in the hypothetical, then later change your mind, that still means something. And that's, I think, in the associational context, in the context of speech, that is a severe burden. If I could turn to the state's interests, for much of the same reasons that when the state says it's so easy for someone to just comply with this and just get around the requirement by signing up as a member of the party, it's the same reason why the state's arguments for why it has an interest in requiring it don't make sense. And I've explored those pretty exhaustively in my brief, I think. So what I'll say is this: I don't think the legislature was, when it put this law into effect, I don't think it was concerned with parties allowing independents to run their primary. I think that was a way of it reflected what all parties up until this point, what they want, what their own internal rules, which we only want people who are members of our party running for office. And that provided a legal way to keep interlopers from running the primary. So I don't think the state's interests here are strong. I don't think they're well served by this rule. And I think they do not stand up to the very heavy burden in an associational context that this restriction places.
Would you address Ms. Fox's mini nonpartisan primary argument?
Well, I'm on the view that that's already a risk. It's always going to be a risk under Alaska's system because we allow open primaries and because, as Ms. Fox has said, it's so easy to just put your name down. That's always a risk. And the question isn't, is this hypothetically something that can happen? And the question isn't, is this hypothetically something that can happen in a single election? It's in the long term. In the big picture, is this a real risk that we need to be concerned about? And there are a number of things that guard against this being a real risk. The first is that you still have 75,000 or more registered Democratic voters who, again, we don't have a lot of facts or data on this in this case. It wasn't developed much below, but we can, I think it's fair to assume that they are more likely to participate in the Democratic primary. So you still have that weight of voters. And given voter participation rates nationwide, which we know are often low, the people who choose to register are more likely to vote in that primary, and they're going to exert significant influence on who is chosen. So if an independent wins that primary, it still reflects the weight of those voters. And there's also all of the efforts of the party that often aren't visible to people who aren't involved in the political process. The Alaska Democratic Party has a central committee. It has an executive committee. It has full-time employees who work to recruit candidates, to get polling data, to develop platforms, to work on messaging, buy ads. All those people are still working, and they're all still going to be exerting some influence in the result. So yes, is there a possibility of a nonpartisan primary happening? That's a possibility. But it's already a possibility. The only difference is someone signed the dotted line. And I think in terms of, is it something that's likely to happen? I don't think there's much of a risk of that. And even if it did, one election where that happens and the party goes, what's going on? Who loses in that? It's the party. And the party can fix it. The party can say, you know what? We tried it. It didn't work. We don't like what happened. We're going back to only party members can participate as candidates. The electorate doesn't lose out because ultimately if that person wins the primary, even if it's a nonpartisan primary, they win the primary and they get elected, they've convinced the voters that they're the best candidate for the position. So the state doesn't lose, the people don't lose. The victim, if we can call it that, is the party. And let the party take that risk. The party's willing to do that. Let any political party in Alaska that wants to do that and give this a try, let them do that. And I think if you do let them do that, if this court does let this happen, I think there's a very good chance that it will lead to benefits for all Alaskans. From a policy perspective,
Do you think that that is going to ultimately, assuming that the idea that you've just floated comes to pass, do you think that that's going to ultimately destroy the two-party system in Alaska?
no, Your Honor, I don't think so.
Why not?
Because the two-party system in the United States has survived for,
I said Alaska.
sorry, I'm using the United States to just give us a little bit more history and perspective, if
I
that's all
understand
right.
the history and the perspective, but you've also argued that Alaska is different
Right.
because of its strong independent majority here, nonpartisan. So I'm thinking just about Alaska and the
Yes, Your
two-party
Honor.
system.
I'll focus on Alaska. I don't think it's going to affect in Alaska. Or, sorry, not affect, I don't think it's going to destroy it in Alaska. Because I think ultimately there's going to be a natural tendency when you get to the political processes themselves for people to align into roughly two distinct groups. I mean, we can see that right now with the current legislative majority, which is a coalition, but there's still another group. The two-party system is going to continue because I think people necessarily, when there's on any issue, there's going to be often two sides. And we're going to see that continue. The registered voters for both parties are still going to be they're going to influence, and the parties and their structure and the recognized political party system is going to self-reinforce, because the support you get as a candidate with a political party that's recognized behind you is significant. It's different. Your access to fundraising, your access to that institutional knowledge of people who work on campaigns and knows what works. And I think that goes back to why it's important that these independent candidates have access to that if the party's willing and if they're willing. Because it gets them, it improves their odds of being selected by Alaska's voters. And I think that's going to have a moderating influence. I don't think it'll destroy the two-party system, but I do think it'll make it less partisan. I do think it'll get us candidates who are less likely to be in one extreme or the other. And in a time in our country where hyper-partisanship is, I think, a problem, Alaska can avoid that. Alaska's uniqueness can play a role in avoiding that for our state.
But one piece of the uniqueness that the two-party system looks at and depends upon is that on each side there's a standard bearer who bears the standard for that party. If you are allowing these independent, non-affiliated people to become the candidate for your party, they don't really bear that standard, and that seems to be an underpinning for much of the law, both federal and state, that looks at parties and their rights of association.
Yes, Your Honor. Absolutely.
So if you take that away, a piece of your foundation is gone.
I think it depends a lot on what we view the standard as being. Is the standard the flag of the Alaska Democratic Party? Is it a big D on a stick and you're waving that around? Or is it the common political goals that party shares with both internally and with some percentage of those independent voters? I think the party can say that our standard isn't, we're going to, it's going to be way out here on the left or way out here on the right, or however you want to divide the political spectrum. It can be, our standard is these common policy goals that we share with this person. And they can make that choice and say, we think that's what's best for us and best for Alaska, and we think that the other party or the other parties that we are competing against, that their goals, that their standards, whatever they may be, we prefer our common policy goals to theirs, and we will support someone who's more likely to get elected, because political power is about winning the elections, and it doesn't make sense to have a standard bearer, to use your conception of it, Your Honor, or the way it was presented in your question, rather, who's out there with the big D, if that flag is never going to get planted. It's better to have someone who advances policy goals that are more aligned, even if it's just tilted slightly in your direction as opposed in the direction of the other party, than no one at all. Sorry, I'm just going to refer to my notes for a second.
If we were to conclude that this was not necessarily a substantial burden, but was somewhat less than that, would federal law dictate, at least implicitly, I guess, from the cases that came after Tashawn, that the state's statute is a reasonable restriction or reasonable regulation?
No, Your Honor.
Why not?
Because it's a poor fit. Even with a minimal, even if the court would have decided this is a fairly minimal burden, I think because it's so easy to circumvent the statute, and so many of the state's concerns in its brief about how if the rule doesn't exist, people could abuse the system, those are all circumvention. If you're willing to circumvent it in that way, then the barrier of simply signing your name up isn't going to stop someone from abusing it in that sense. So I don't think there's really, the interest isn't served really at all, or or so minimally that, any burden on the right isn't going to do it. And on that topic, I think even if the federal Constitution ultimately doesn't give a basis to strike this law down, the Alaska Constitution does. This court in Green Party, in applying to Tashtian, and in not applying Klingman v. Beaver, I think indicated that it's taking a more protective route that reflects...
No, I understand that, but to do that, of course, it had to find a severe burden, right? So then you have more like a strict scrutiny, and you have to find a much closer fit. And I'm just suggesting if we don't find a severe burden in this context, this is not the voter context, this is the candidate context. So just assume for the moment that we don't find a severe burden, then it's a different test. And it could be that the feds have given the states some more authority in that neighborhood, have they not?
I think they have. I think they have. I think the cases, though, that have addressed it are, in many ways, distinguishable from this issue. Voter qualification, these are typically voter qualification cases, and the voter qualification candidate qualification
Candidate
cases.
qualifications.
I misspoke, Your Honor. My apologies. The candidate qualification cases, they've never been on this basis. They've always been on, in the same way in free speech cases, you have time, place, and manner restrictions. These have always been...
Well, there's some that are close. For example, the ones that say you can't, there's a certain period of time that you have to register from one party to another, right?
Yes, Your Honor.
What's that? Is it store or maybe? I forget the names of the cases.
I don't recall off the top of my head.
But doesn't that necessarily imply that you have to be registered?
It does, but I would say the burden in those cases is very different, because it's not saying that you have, the parties weren't saying, we want someone who's not registered to run, and the restriction was temporal. The candidate isn't saying, I don't want to maintain my identity, or rather, I want to maintain my identity, but I can't. Instead, it's, I want to change my identity within 6 months or within 9 months, and I'm supposed to do it in a year. It's a temporal restriction, and it's limited. It affects one election. But in this case, the candidate who says, I want to maintain my identity, they will never, ever be able to run as a candidate for a political party in their primary. And that's the distinction from my point of view, Your Honor.
Implicitly, it seems to me that if it's okay for a state to say you've got to be a Democrat for 6 months, that it might be okay to say you got to be a Democrat for a day, implicitly.
And as I think about that, I take it one step further. We're talking here today about what the Democratic Party of Alaska wants to do, the Alaska Democratic Party wants to do. But there's another party in Alaska that doesn't have this, and they don't want to do that, and they require their party members to become candidates to sign and agree to their platform. And that's what they want to do, and that's perfectly legal, isn't it?
Yes.
from their point of view. So we're really talking about the party's interest, not so much, I mean, because in the case of the other party, while there may be the same independents who have the same burning desire to maintain their identity, but they still support some of the ideology or some of the platform of the other party, they can't become candidates under any set of circumstances for that party, right?
Correct, Your Honor.
And there's nothing wrong with that.
There is nothing wrong with that because it's the individuals making the decision. It's not the government making the decision for them.
Well, it's the party that's making the decision, not the individuals. The individuals in the other party have no role to play. They can't make that decision.
I apologize, Your Honor. When I say the individuals, I'm referring to both the candidate and the individuals who make up the party, the association. But I will be more careful with my language moving forward.
Go ahead.
Last, I think I have about 3 minutes left, so I'm going to turn to the ballot issue. The state has not submitted an affidavit or any evidence from the Division of Elections that it would be impossible to come up with a ballot that would be fair. And I don't think there's any evidence before this court, and I don't think the state's arguments establish that it's impossible to come up with a fair ballot. The Alaska Democratic Party did not suggest a specific ballot design, and I'm hesitant to do so, even though the state's reply brief suggested that we have some duty to do so, because there are so many other stakeholders who may be affected. But I will.
Even if you're not willing to suggest a ballot design, can you tell us what your objections are to the state's proposals?
I think one of the problems, as I recall, was that it did not sufficiently convey the fact that the person was not a registered Democrat. And I think part of this is they are nominated by the party, but they do get to retain some of that identity. And so it should say that their voter affiliation, even if it's not affiliated. That should be,
candidate's voter affiliation.
The candidate's voter affiliation should be marked.
Why?
Because I
They
think
want to be in the Democratic Party primary. Why?
because it's part of the identity. It's part of the reason why the party is doing this, is because that does have some value. It does signal something. It does signal some differences from the party, and these people may be more electable. They may appeal more to the broader electorate because of it. To the extent that candidate labels matter, that matters.
And what about the primary ballot? Is it okay to have the candidates' registration status and then designate which party primary they're running in?
Yes, absolutely, Your Honor. As I recall, the Alaska, in our opposition to their motion to adopt the ballot, I mean, part of the issue was that there wasn't really a controversy because we didn't have any problem with that ballot. And so the suggestion that I made in our brief before this court, which I think is still a fine suggestion, and an example of a way that the state could accomplish many of its goals without some of the semantic conflict, is just to put registered nonpartisan, registered unaffiliated, nominee of. And there it's clear that what they're registered as and who nominated them. And I don't think it's an impossible ballot or an unreasonably confusing ballot. I see that I'm out of time, so if there are no further questions. Thank you.
Evidently not. Thank you, Mr. Choate. 3 minutes, Ms. Fox. 3 minutes.
Thank you. So, on the one hand, it's not a severe burden to require the candidate to register as a Democrat in order to bear that party's standards, because if the candidate really wants to advance the Democratic Party's platform, then registering as a Democrat would be the consistent thing to do. And on the other side of that, if the candidate really doesn't want to, because that's not who the candidate is, the candidate doesn't really want to sign on to the Democratic Party's platform, then that candidate should not, under a partisan primary system, be the nominee of the Democratic Party, because that makes the partisan primary system no longer make sense, because the point of having a partisan primary system is that the different parties will nominate candidates to support their platforms. And the party can change its platform in any way that it wants. If it wants to appeal to different sets of voters, it can change everything about, you know, what sorts of views and policies it promotes. But and it's fine for a candidate not to be a Democrat. The state's not saying that anybody should be forced to sign on to any particular party or any party at all. That's why the state has a different system, the petition system, for a candidate who doesn't want to sign on with the party. Such a candidate doesn't belong in a partisan primary if the candidate does not want to sign on to any party. So that's why that alternative is provided. And the state's not interested in a two-party system, or it just it has a partisan primary system. There can be any number of parties, whatever ways that the voters want to group themselves in. But the legislature has chosen a partisan primary system, which only makes sense if voters that want to. I mean, anybody can remain nonpartisan and use the other system if they want to, but the people that want to can group together in parties and nominate candidates who support their party platforms, which they can change in any way to appeal to any set of voters that they want to. And so the state's interest is in preserving the coherence of that partisan primary system, which is the system the state's chosen, like many other states have, as opposed to sort of a blanket nonpartisan primary system that some other states have chosen. And just because the rule is not perfect, I mean, the perfect shouldn't be the enemy of the good. It still makes sense to draw this line between people who are willing to publicly say that they support a party's platform and people who are not, people who refuse to do that. I mean, because they don't, you know. And so it still makes sense, even though the system could be circumvented, it's still a reasonable distinction to draw, and the state can't have some sort of ideological purity test. So making a distinction between people who are willing to say publicly that they affiliate with the party and its ideas and people who refuse to do that still makes sense. And just briefly on ballot design, the state's argument is that its interests, that it has a state interest in preventing voter confusion and deception that's promoted by this rule because all of these ballot designs, in the state's view, are problematic. And if the court disagrees with that, because it thinks that some or all of these ballot designs are not problematic, and the state's not asking the court to pick a specific one, but if the court thinks that the state's wrong about all of these being problematic, the state respectfully requests that the court's decision indicate which design or set of designs, range of designs, that the court thinks is not problematic, because the state considers them all to have these problems.
What about the alternative of adding the word registration before the candidate's registration on the primary ballot? Doesn't that get around the problems that you're suggesting?
I think adding the word registered does not eliminate the inherent semantic conflict between the word nonpartisan or the word non-affiliated and the indication that this person has been nominated by a party.
But it does explain it.
It may
There is an
go-
inherent conflict, but you can define things by the way they're presented, and that would be one way
It
to
doesn't
do it.
eliminate the sort of confusing inconsistency in it. I mean, it may go some of the way to explaining it, but it's still a person who's been nominated by a party is not nonpartisan.
But what if we assume that voters are adults and will inform themselves?
I mean, voters, there's a range of different voters who have a range of different information, but again, it's confusing and also deceptive to call somebody nonpartisan when they are party nominee, because that is not what they are. They are not nonpartisan if they're a party nominee. So the conflict can't be completely eliminated in the state's view. So
Thank
there
you,
are no
Ms.
further
Fox.
questions. Thank you, Your Honor.
So here we are. The court wants to thank the lawyers for your briefing and for your argument today. And again, thank you for being willing to do this here in the high school in front of these students. We'll take the case under advisement. We will issue a written decision at a later time, and we will be adjourned for the day. Thank you.
why don't you just stand up and shake a little bit for a minute, get some of that energy out, and then have a seat? Yeah, you guys probably need it more than anybody. All right. I want to thank you for being so attentive. I don't know if you were following as well as it seemed like, but you were very quiet and attentive, and I'm sure the court and the attorneys appreciate that. So I'm Marilyn May. I'm the clerk of the appellate courts, and that means I'm the administrator for the Supreme Court and the Court of Appeals. And I'm just here to moderate this little question and answer session with the attorneys from the case. So this is to allow students only a chance to ask questions of the attorneys. You can either specify who you want to ask or let me choose if you don't care. And go ahead, if you've got a question, there are 2 mics here, so you can go ahead and form a queue. Come on. There, we've got somebody. And I'll just turn over my... Oh, she didn't. Oh, it was a trick. You can ask them about the case, about their strategy, about why they're a lawyer or where they went to law school or whatever you want.
I was going to ask about education. My name is Jody Sparks, and I'm a senior, so I'll be going to college next year. And I was wondering what each attorney, what you majored in undergrad. Thank you.
I studied economics in undergraduate, which is, I think, not uncommon for many people who end up in law school.
I majored in psychology with a minor in computer science.
I was a history major. I think even more common amongst lawyers than economics.
And I have a master's degree in German from before I went to law school, which has nothing to do with it. Okay. You can form a queue if you, come on, we got to have some people that have questions here. Go ahead.
This is more about the case. For
Ms. Fox?
yeah, you say that it's equal, but it's much harder for an independent to become a candidate, yes, because of the system set up.
Well, so it's harder in one way in that the independent candidate has to gather signatures and the other candidates don't. And in another sense, it could potentially be easier if, a primary might have a bunch of candidates running, so it might be very difficult to win a party's primary, whereas, if you can manage to gather enough signatures, you can get on the ballot in that way. So it's a different system. But yeah, that's the system the state's set up, having parties have primaries and having independent candidates have this other route to the ballot. And a lot of states have a similar system.
Hi, my name is Alexis Corey, and I've got a question for both of the lawyers. In the case, you said that the candidate was... I don't exactly remember because I wasn't exactly paying attention, but can I remember this real quick since I'm pretty short? You said that the candidate, if he or she wanted to, they wanted to participate, but they were non-affiliated with a certain party, in this case, since it's the Democratic Party, they wanted the, they want to put nonpartisan people on their primaries through I honestly, but if per se, you wanted to put a nonpartisan person onto the primaries, what if that person, they sort of betrayed their party in a sense? Like,
So they run as a Democrat and then
like
they
they,
don't espouse.
what if they switched to another party, maybe like after the primary election? Like, per se,
Let's give them a chance.
oh yeah, sorry.
So that's one of the core, I think, debates we've been having in our briefing in this case is what guarantees does this party membership requirement create? If I'm a registered Democrat and I sign up to run in the Democratic primary, no one asks me what I actually believe. So in theory, I could actually believe things that are totally different from the Democratic Party. Similarly, if I'm an independent, I may share a lot of beliefs with the Democratic Party. But one of the states that, and I'll let Ms. Fox speak more to this, one of the state's arguments, of course, is that there is still some connection there, and if I don't register as a Democrat, then it's more likely that my views are significantly different, and that me being on the Democratic primary, maybe being elected, means the Democrats have a nominee that doesn't actually share any beliefs with them. But I'll let Ms. Fox.
So your question is actually similar to one of the questions that I think Justice Stowers asked when I was talking, which is he said, well, what's to stop somebody from, after they win the primary, then they could just change their registration back. And yeah, the law doesn't specifically prohibit that, and it doesn't guarantee that the person is going to share the party's views or that they're going to have, specific views. There's certainly a range of views that people in a party could have. The state's position is that it's still reasonable to make a distinction between people who are willing to say that they're a Democrat and that they support the Democratic Party and people who are not willing to say that, who want to say, no, I'm not, I'm independent, and that that distinction makes sense even though, you could sign up as a Democrat and then betray the party or, the party's views.
I just have one more question. If someone per se had sort of the same views as a Democrat and the same views as a Republican or a Libertarian, and they were registered as an independent, but they feel like it would be best that, what if someone started their own party following these rules? Would that make any difference to the Alaska legislator?
So there's a whole process in Alaska, and I think Ms. Fox knows it better than I do. She does these cases, or Ms. Peyton Walsh actually does a lot of these too, by which you become a recognized political party. So, in this auditorium, we could form a political party, but that doesn't mean that we get a spot on the ballot or we get to run our own primary election. You have to get recognized political party status, and there are different ways you can do that, and I'll hand it over to them to explain that.
Yeah, so certainly an individual or a group of people could start a new party with any sort of views that are different than the established parties. And what they would have to do is first, they'd start their group, they get a bunch of people, they'd sort of decide amongst themselves what they wanted their new party to stand for. And then there's two different ways they could get official recognition. One is if they get enough people to sign up when they register to vote as being affiliated with this party, so if they get enough registered voters, they can get party recognition, or if they nominate a candidate, so they would have to use the petition process, so if they do nominating petitions for a candidate, and then that candidate in the general election gets enough percentage of the votes in a statewide election, that's the other way that the party could get recognition, is if their candidate is popular in the general election. The candidate wouldn't have to win, but if the candidate was popular enough, then their party could get official recognition. So then it would be an established party like the Republican Party or the Democratic Party or the Libertarian Party.
Thank you.
This is our 11th Supreme Court Live. We've been to West High School in Anchorage 5 times, I think, and we've been to Juneau, Fairbanks, Barrow, Ketchikan, Sitka, and Palmer. Maybe we're at 12. I don't know. I didn't count that right. But there have always been lots of questions, so you're going to disappoint me if you don't have lots of questions. And you're next, please.
Hi, I'm Jalen Stroman. I'm from Nikiski. So I have like a couple questions that's like about the case and then some stuff that's like about not the case.
Let's start with the case one.
Okay, so the Democrats are trying to get the independent party to be passed as legal so that more people can vote or be like part of their party?
What's at its basic, in Alaska, you can be a registered member of a political party, and we currently have 3 recognized political parties, right? Yes. 4? 4, okay. Oh, the Independence Party, sorry, I forgot one. So you have 4 recognized political parties. So you can register as a member of one of those, or you can register as what's called a non-affiliated registration, which is nonpartisan or undeclared. Sorry, I'm a little fried after the argument. So what the Democrats want to do is, historically, all the parties have required people who want to run for their nomination, to be their candidate, to be a member of the party. The Democrats changed their rules to say, we'll want people who are Democrats, but also people who are registered not as a member of any other political party, right? So we broadly independents. They're not members of any other political party. They can also run for our nomination. That's what's at issue.
Okay, now, let me go over here. Okay.
Hi, my name is Maisie. I was wondering, I had a question in reference to your argument that this would essentially move us further away from what legislation had chose as the partisan system, and I was wondering what would be the consequences if we started to move more towards a nonpartisan system and how that would affect our legislature.
I'm not sure, actually, the political implications of switching to a nonpartisan primary system in Alaska would be. So the way that the law has set this up, so the Alaska legislature has set up this election system that has partisan primaries. And yeah, I was making the argument that changing this rule would sort of mess up that system. I think if the Alaska legislature on purpose chose to restructure the statutes to have a nonpartisan primary instead, they could do that. There are some other states, off the top of my head, I think maybe California has a nonpartisan, Washington maybe. There's some other states that do have a nonpartisan primary system. The way that works is there's a primary election, but it's not associated with a particular party. So anyone can run in the primary election, and then the top candidates who win the primary election, so the ones that get the top 2 votes, maybe, depending on the system, then advance to basically a runoff election. And so the parties, there's still political parties in those states, and they still do their thing. They give money to candidates, and they run ads and everything, but they are not part of the primary system exactly. And so the candidates, it's just the top candidates in the primary advance to the general election, not as particular party nominees. And I'm not sure how that would, if the Alaska legislature switched to that system, I don't know what the political, how that would change the politics.
So why would
in
it
the
be
state.
a threat to the case itself? Why would it be a threat to the legislation if it did start to move more towards a nonpartisan?
Well, it just wouldn't, the system has been set up with a partisan framework, and taking this rule away would screw up the system. It wouldn't change the state to having a nonpartisan system. Instead, it would have kind of a messed up partisan system where you'd have, some partisan primaries and some kind of a hybrid primaries. So it would be, it wouldn't work with the system that the legislature has chosen. So if the legislature changed to the other system, they could set it up in a way that would make sense. All right.
Thank you.
Okay, over here.
Hi, my name is Tristan Groom, and I was wondering what values the Democrats are looking for, or whatever they're looking for, that they can't find within their own party.
That's a good question. I think, really what they're doing, the goal of this all is to encourage more Alaskans to run for office. I think that, I don't know if anyone participated in like March for Our Lives last weekend or anything like that, but there is, I think, a lot of energy in this country for people to get more involved politically. And the Democratic Party is the smaller of the two parties in Alaska. And I think they want to encourage more people to run and get involved in politics because by bringing more people in, hopefully, we will get elected officials who better represent what Alaskans want.
Thank you.
You're very welcome.
Okay, right here.
Okay, so I have a question based on if the Alaska Supreme Court sides with the Democratic Party and where it will allow anyone that they feel represents them best to run, even if they're not registered as a Democrat, but they register to vote. How would this affect any party on the national level? Would it allow anybody who's not affiliated with a party to just say, I'm not going to declare as a Democrat or I'm not going to declare as a Republican, but I'm going to run for, say, senator or president, or like on the national level?
That's a great question. It would only affect Alaska elections. National elections would not be affected.
But do you think it would have any influence on future cases?
Well, so one thing that happens when people argue these cases is you look to what's happened in other states and the basis for those decisions. So it depends on whether our Supreme Court, if they assuming they side with the Democratic Party, what's the basis for that decision? And other states and other litigants in those states, people challenging laws who want to change laws, they could look to this decision and argue that it's persuasive. A decision here doesn't set the law in another state, it's not precedent, but you can look at the reasoning and say, well, that provides a good reason for us to do that here as well.
Thank you.
Okay.
Hi, my name is Mikey Eitz, and I have a question for the male. What advice do you have for students that want to pursue a career in law?
Read a lot. I think part of being a lawyer is you have to read tons and tons. And writing is important too, but the easiest thing you can do to improve both is to read a lot. I think it depends a lot on what you want to do, but one of the nice things about law is that you can study anything you're interested in when you're in college and still go to law school. You don't have to study anything particular. You don't have to do pre-law. Things that are good for logical thinking are really helpful for the LSAT. So if you do computer science, mathematics, economics is what I did, those are really helpful. And also just learn about the law. Get a part-time job or an internship or a summer position at a law school, or volunteering at a legal services clinic. I know the state has some internships, right? Or did?
Oh, it has internships
for law students.
Sorry, I'm going to cut him off right there because we only have time for one more question for the attorneys. Then I'm going to go get the court and bring them in, and if you've got a question you'd like to ask the justices, we can do that. But I will give you one caveat. You can't ask the justices about this case. They can't discuss the case. But you can ask them about their careers and, what it's like to be a justice and all that sort of stuff.
Hi, I would like to ask both lawyers, so specifically in this case you're discussing the ability for a nonpartisan candidate to run in either primary for Democrats or Republicans. Do you think it could be advantageous for that candidate if they were to, say, remove other candidates from those primaries if they won? And do you think that that would be unfair?
Okay, I'm going to ask them each to give a quick answer.
I think there's different strategies that the parties and the candidates could be trying to employ in these cases and in this situation. I don't know that I would say that any particular strategy would be unfair exactly. the state's position is that the candidate representing a party should represent the party and, sign on as part of the party, and that otherwise it would be sort of, but I don't know that I would say anything would be unfair.
Yeah, I think it's a complicated political question that goes to political strategy, which is outside of my expertise. But there are trade-offs. If the candidate wins, they are the candidate for that party. So, yeah, an independent, in theory, could take the spot that otherwise a Democrat, or if they were on the Republican, and the Republicans changed their rules to allow it, they would take. On the flip side, if they lose, they can no longer get on the general ballot by petition. So there are trade-offs.
All right, you came through in a big way. Good for you. And the attorneys can take your seats now down there, and we'll have the court come in here just in a moment. So thank you. Good questions. Now's probably a good time to find a seat down here. Thank you both. It's so great.
Very good, very talented. All three of you hit it on the same beat. There you go, thank you. Ready, guys? 1, 2, 3. All right. Now that we got that over with. So, good morning again. All right, time to be quiet, please. We're here now mainly for you, and I think that the drill has been explained to you, that people can come down to the microphones. We're not going to have time to answer everybody's questions. I know this based on experience because we've always left a couple of people standing in line, and I'm sorry about that. But one thing that we're going to try to do is to shorten up the discussion that we have had historically, telling stories up here on each other. That's never gone very well anyway, because, I'll tell a story about him, and then he'll tell a story about me, and then, we're all embarrassed. So we'll just keep it short. My name is Craig Stowers. I'm the Chief Justice of the Alaska Supreme Court, and I will turn it over to my friend on the right.
I'm Dan Winfrey. I was born and raised in Fairbanks. I came here about 48 years ago and played basketball in this high school. I'm the senior justice on the court. I've been on the court for 10 years, and I'll pass it on to my colleague here to my right.
I'm Joel Bolger. I'm also a justice on the Alaska Supreme Court, and I've been on the court since 2013.
I'm Peter Mawson. I've been on the court since 2012, and I was born and raised in Michigan. I've been here for about 38 years now.
I'm Sue Carney. I'm the newest justice. I've been on the court for about a year and a half. Before that, I was a public defender and public advocate. I've been here since 1987 when I took a one-year job that has turned into a very long year.
All right. So do we have any questions from anybody? Good. Okay, this was going to be short.
And remember that we can't answer any questions about the case.
Hello, my name is Liz, and I was wondering what type of schooling you guys went through and how long did it take to get to the point where you guys are right now?
All right, one more time. We couldn't quite hear.
What type of schooling did you guys go through and how long did it take to get to the point where you guys are right now?
All right. Yeah.
Well, okay, schooling, well, of course, Lathrop High School, and then undergraduate school, of course, 4 years, and then off to law school. Law school takes 3 years. So there, and then me particularly came back to Alaska. I practiced for 25 years, and then I was appointed to the court. I practiced primarily civil litigation all across the state, but based out of Fairbanks for the most part, Anchorage and Valdez for a little bit.
So what he just said is generally true for all of us. All of us went to undergraduate college, and then we all went to a law school. Just to give you an idea, though, let's do it this way. Justice Bolger, what did you study in undergrad?
I was an economics major.
I was a finance major.
I was biology.
I was pre-med until I realized I couldn't cut that, and so I became a political science major.
And I majored in history and English.
And so the point of this exercise is that I think, you know, to be a judge and indeed to be a lawyer before you become a judge, you can probably study anything that you're interested in. And that's usually the advice I think that most guidance counselors would give you. You know, if you enjoy what you're going to be studying and you do well in it, that's going to be important. Whatever you do, learn to write well.
Thank you.
You're welcome.
My name is Kai McKibben. I'm just wondering what you guys ate for breakfast this morning to prepare you for this day.
Really? You want to know what we ate for breakfast? Why do you want to know that?
Well, like what prepared you, like what you ate to prepare you for this day.
I don't mind telling you what I had. I can start out. I didn't realize that there wasn't any breakfast available in our hotel, but I had bought a bag of caramel corn for the road yesterday. So I had a little bit of that to get me going, and then I was happy to see that the school actually provided some better food back in the green room.
Thank you.
The
Next
school has
question.
provided a big spread.
Next question.
What does your daily job look like when you're not in a case and in a courtroom?
I'm sorry, I didn't hear that.
What does your daily job look like when you're not in a case or in a courtroom?
Okay. Justice Carney?
We read and we write a lot. We have 3 law clerks that help us who are recent law school graduates. A number of them are here, over in the front row here. And if you corner them, they might tell you what their day is like.
Or what they had for breakfast.
But we read and we write a lot. About 3 days a month we do oral arguments like this. Not always with as big an audience or as interested an audience. And about 3 days a month we also we meet together to confer about cases where people didn't ask for the oral argument. All of these lawyers probably have cases where they've written briefs to us, but they don't come in and argue.
Thank you.
Thank you. Yes, sir.
Hi, my name is Alden, and maybe I'm just uneducated and literally everybody else in the room knows, but how did you get to this point? How were you appointed this honor of being a justice?
Okay, so I'm going to talk just very briefly about how Alaska selects its judges. Not all states do it this way. Some states, judges are elected just like you would elect a senator or a representative. The founders of our constitutional process decided that we would have a merit-based selection process. So what this means is that any lawyer who is in good standing in the Alaska Bar can apply to be a judge. And they fill out a very detailed application. They fill out releases so that all kinds of information can be gathered and studied, credit reports, criminal history, court history, all kinds of other histories. We have an independent body called the Alaska Judicial Council that's created by the Constitution. And this is a group of people that are made up of 3 citizens, 3 lawyers, and then a Chief Justice chairs it. And this group and the staff of employees that assist them vet all of this information that comes in. A poll is sent around, a survey to every lawyer in the state, judges, and others, and all of the lawyers and judges will rank these candidates and also make comments about them. The candidate will come in and interview with the Judicial Council. The public is invited to provide testimony about the individual, and then the council meets, it confers, it nominates, usually 2 or more, to the governor, and then the governor selects. So that's how it's done in Alaska.
Thank you.
For your information, sometime this coming summer, the Judicial Council is going to be here in Kenai because one of your Superior Court judges is retiring, and other lawyers are going to be applying for that position. and there will be an opportunity for the public to come and give testimony, and that will get published here on the radio and in your paper, and you can also get that information at your Kenai courthouse, and all of you are invited to come and sit in, and if you wish to offer comments about the individual candidates for judge, as long as you don't say what they had for breakfast, serious comments, you're welcome to do that.
All right, thank you.
Yes.
Hi, I'm Hunter Fitt, and I was just wondering, what desires fueled you to become a judge?
Justice Bolger?
When I graduated from law school, being a judge was probably the furthest thing from my mind. I was a legal aid attorney and I was a public defender and I just wanted to help people. But as time went on, I realized how important the judge is in our judicial system, and so I decided that it would be good to be in a position where I could make decisions that would affect people's lives, and so that's why I made that decision. I was a trial judge in Valdez and Kodiak, and then I was on the Court of Appeals before I joined the Supreme Court.
Mrs. Winfrey?
I think the desire to become a judge came late in my career, and at some point I just thought it would be really great to do some public service, and serving on the Alaska Supreme Court just kind of called out to me, and so I gave it a run, and I was unsuccessful the first time, and then there was an opening when I was about 55, and I realized that if it was going to happen, it was going to happen that time, or it wasn't going to happen at all. And so I put my name in and went through the process that he asked about and just described, and I went through, and the governor appointed me, and so here I am. And it's a fabulous job. I think everybody here would tell you that it's a lot of fun. We all enjoy it. We love the process and the intellectual challenge, listening to people debate fine points of law and trying to come to an answer of very difficult questions, and providing the public service to the state of Alaska. We all love it.
Awesome.
Yeah, just one thing that I can add. I think, like all the other justices, I had a litigation practice, and when you're a lawyer in litigation practice, as the lawyers who presented today know, you're always taking the best position you can on behalf of your client, but it's not necessarily the position that deep in your heart you think is the correct one. It may not be the result that you would reach if you were the decision maker, and there's something really rewarding and comforting in being at the end of the road in that sense, where you're actually looking at the arguments presented by two sides and deciding which one is really the correct one, and writing up an opinion on that basis, as opposed to just trying to think of what the best argument you can make is on behalf of a particular individual or organization. Justice Carney?
I never thought I would be a judge. I was a public defender until a year and a half ago. I was persuaded to put my name in when Justice Fabe retired, and I was appointed, and I'm extremely honored, but it wasn't anything I ever planned on.
So I'm going to add sort of to comment on what was not said. What you did not hear is that any of us wanted to be judges because of power or prestige or glory or an easy job. I think that, and I'm speaking broadly, and this is my opinion, I think that Alaska is blessed with some of the finest jurists of any state in the country. In large part, I think that's because the system that selects the judges, which I mentioned a minute ago, is a merit-based system where the people who apply get vetted very, very intensely. And it's not something for the faint of heart, and it's not something for someone that just wants to be a judge because they think that it's cool to walk around in a black robe. It's a very demanding process. And then once you become a judge, it's one of the hardest jobs that you can imagine, and people just don't understand how much time it takes to do the job well. And I'm not complaining. All of us love the work that we do, and we do it. And we all thank our spouses or our partners who support us and put up with it, trust me. But it's really, really hard work. You know, sometimes we're the first there in the courthouse in the morning, and sometimes we're the last to go. And occasionally we see each other there on the weekends, but it's very rewarding, and principally because we're serving the public. And if that's not your primary goal, you have no business being a judge. And I appreciate your question. Thank you.
Thank you very much.
Yes, sir.
So I have a question for Justice Winfrey. You said you're from Michigan, is that correct?
No, it'd be Justice Massa is from Michigan.
Yeah.
Okay. How excited are you on a scale of 1 to 10 that Michigan is in the Final Four?
I'd give it an 8. I guess it should be a 10, but I haven't kept close tabs on
Do you think
college
they'll beat
basketball
Loyola on
since that.
Saturday?
Pardon me?
Do you think they will win on Saturday against Loyola?
Of course.
Of course.
You redeemed yourself.
Thank you.
I have a question for Chief Justice Stowers. What steps did you take from getting from a park ranger to Chief Justice of the Supreme Court? And what's the timeline? Thank you.
And what was the...
And what's the timeline?
The timeline. All right. So should I tell him the truth or should I tell him my story? Tell him the story. All right. So I was a park ranger at Mount McKinley National Park, and this was before the park's name was changed to Denali. And towards the end of my tour of duty there, I and a couple of other rangers climbed Denali. And as you know, it's approximately 20,320 feet. There's a real risk of high-altitude cerebral edema. And in fact, one of the climbers that was on the mountain at the time suffered that disease. And we ended up having to rescue him and bring him down to altitude in order to save his life. It has been my belief that I also suffered high-altitude cerebral edema.
Ours too.
Because I ended up giving up the very best job that you could possibly imagine so I could go to law school so that I could then work really hard and save up my leave and save money to go and pay to do the things that I used to get paid to do. Most of that is true. Yes, sir.
My name is Jody Sparks, and my question is for Justice Winfrey as the most senior judge on the court. At the federal level, it appears that the judiciary is becoming increasingly polarized and based on politics. And I'm wondering if you've seen that happen in Alaska and what you think is going to happen in the future. Thank you.
I can tell you that that our court is completely unlike the U.S. Supreme Court in the sense of ideological divisions and polarization. We as a group work extremely well. We have no ideological fights. Of course, one thing you have to know is that the kinds of cases that we decide are a lot unlike the kinds of cases that the U.S. Supreme Court decides. They only decide the cases they want to decide, and they don't decide very many. They decide maybe 75 or 80 cases a year. We decide a couple hundred, several hundred a year, automatic appeals, and for the most part they're uncontroversial. But nonetheless, we work very hard to be collegial, and it's not very hard to do that. And I don't know that there's...
Knock it off, gentlemen. Thank you. Go ahead.
And I don't know that there's much in the way of any problem in the trial courts. Certainly, I'm unaware of any, but I can tell you that on our court, there's nothing like that.
Thank you.
That was a great question. Thank you. Yes, ma'am.
Hello, my name is Alexis Corey, and I was wondering, in case anyone wanted to be a lawyer or a judge or even a clerk, what classes would they have to take in high school and or undergraduate college in order to be able to go into law school?
I think, just referring back to the answers we gave a little earlier about our paths to judgeships, all of us came from different backgrounds in college, and I have no idea what any of my colleagues took in high school. I know that they got through high school, and most of them have high school diplomas, or at least that's my assumption. But I think the focus needs to be on being able to think independently and being able to write. Being able to write is incredibly important in this job, and write persuasively and clearly, because a lot of what we do is explaining our thinking to the public. You know, we publish opinions every Friday or almost every Friday. Some opinions come out from our court, and we're trying very hard to make the litigants and the lawyers believe that we understood what they were telling us, and if we reject their arguments, there's a reason why we rejected their arguments, and we're not just being arbitrary. And those opinions, at least some of the opinions and issues like this one, will be read by the public at large, and we want the public at large to understand why it is we reached the result we did. So clear thinking and translated into clear writing is very important. So anything you can do to work on your writing ability will be helpful.
Thank you. Yes,
You're welcome, Your Honors.
I have a question that can kind of be broken up into two parts. And the first one is, what's your favorite part of doing this exercise? And the other one is, which one you think is the most beneficial to the students in this auditorium?
I didn't hear the first part.
It's very difficult to hear.
Yeah, restate your question, please. We're getting some reverberations here.
I was just curious if, which part of this exercise that you enjoyed the most, and which part you think is most beneficial to the students.
Well, I hope you like the part that I like, which is just the opportunity to hear two wonderful lawyers explain kind of a complicated point, and it really is wonderful just to sit back and to consider these arguments, be able to ask questions, to try to get the answers that we need to make a decision. I take great pleasure in that. And I think that for the students in the audience, I think you should realize that this may be a once-in-a-lifetime opportunity. Not many Alaskans have seen an Alaska Supreme Court argument. And I think just the opportunity to see your government at work in this way is important. So I hope you have enjoyed it.
We are very quickly running out of time, and so I'm going to use this question as an opportunity to sort of wrap this up, and I apologize to the rest of you in line. We're not going to be able to get to your question. One of the things that I personally hope for out of exercises like this is that some of you in this room, even as we're here right now, will start thinking about, what am I going to do with my life, and what am I going to study, and what am I going to be? And I want you to realize, and I think we all want you to realize, that there are almost no limits. If you have the basic ability and intelligence and the willingness to work hard and dedicate yourself to some course of study, and if you ultimately wanted to go to law school and you did well as a lawyer, you wanted to become a trial court judge or Supreme Court justice, that's a possibility that's available to almost all of you. And you ought to think about that seriously. I mean, it's too early maybe to say, yeah, I want to be a Supreme Court justice someday. But, you know, for one or two, maybe not. Anything is possible if you really put your mind to it, and if you want it and you're willing to try hard enough for it. So thank you for your question.
Thank you.
Marilyn, where's Marilyn? Hi there. So I think we're at the end. How did we do? Where's the list? Is it? Thank yous? All right. All right, so I'm going to be calling out a number of people under different categories, and these are people who helped put this program together from the very beginning to the logistics of it, to working with you in the schools and classrooms, to helping us get set up here. And I know this is going to be really hard because we've done this before and it's rarely worked, but I trust that here in Kenai, you guys can actually do it because you want to follow instructions, right? So the ask is this: please hold your applause to the very end after we've called everyone's name, and then you can applaud. So a special thanks to the attorneys who who volunteered to visit classrooms to help students prepare for today's programs. We have Carrie Ann Baker, and if you could come up here as I call your name, please. Magistrate Judge Martin Fallon, Parissa Harris, Joseph Cashy, Gwen Neal, Scott Bloom, Mike Graves, Teresa Hillhouse, Sean Kelly, Nan Thompson, Charles Evans, Eric Groves, Lauren Johansson, and Paul Morin. You guys are rock stars. Thank you so much for giving your time. These are people who have real jobs and they need to make real money, and they've got real clients, and yet they're willing to come down here and give their time to you to help with this program, and I appreciate it deeply. And now I'm going to thank the following people for their support. Marilyn, you ready for me to go next? Yes. Okay. Principal Alan Fields, Kenai Central High School. John Pothass, Director, Elementary and Secondary Education, Kenai Peninsula Borough School District. Tim Elder, Theater Director, Kenai Central High School. Casey Olson, Computer Tech, Kenai Peninsula Borough School District. Sergeant Jeremy Grimmie, Kenai Judicial Services, Alaska State Troopers. Steve Pohl, Kenai Judicial Services, Alaska State Troopers. Ann King, Allied Universal. Derek Rivera, Allied Universal. Okay. I thank all of these people for setting up and doing the logistics and providing security and setting up the technology here, and it actually worked here better than in some other places, so good job, guys. Thank you. And then the Kenai Central High School student leadership provided ushers, Candace Bowers, Veronica, and I'm sorry, I'm not going to get your name right, Badianu? Is that close? Okay, yeah. Mara Grimmie, Abigail Moffett, Olivia Brewer, who I understand may not be here today, but thank you, Olivia, for wanting to. Riley Graves, Denali Lockwood, who's sick today. I'm very sorry, Denali, that you're sick. You missed a great program. And Wagnoi Rada Tuphorn. Thank you, everybody. And then, of course, the most critical part with whom we could not have done this program in a timely fashion, the timers Morgan Mallory and Abigail Schneiders. Morgan and Mallory, thank you. Admit it, you got really nervous when you started going into negative time, right? I mean, you got to zero and you sort of panicked. I could see it on your face. Yeah, so did the lawyers. Sorry, guys. Bad joke. And then participating teachers and schools. And again, I apologize for massacring your names. Jesse Borkman, Nikiski High School. Maria Calvert, Kenai Central High School. Chad Hinders, Seward High School. Seward actually wasn't able to come, and I'm very sorry about that. We missed them. Shane Lopez, Soldotna High School. Sarah Singer, Nikiski High School. Michelle Borland, Homer High School. Barbara Dinbor, Nanilchik High School. Taylor Lewis, Soldotna High School. And Jesse Settlemeyer, Kenai Central High School. Thank you, everybody, for your help and support. And then, of course, we want to thank you, the students. And so let's do it this way. First, I just want to hear all of the Kenai Central High School students clap for yourselves. All right. Thank you. Nikiski High School. All right, thank you. Soldotna High School. Soldotna High School. Come on, come on. All right, good job. Thank you all for being here. Did we miss anybody? Is there anybody here from another high school? Homer High School. Come on, let's go. Maryland, is there anybody else?
Ninilchik?
Ninilchik High School. Good spirit, Ninilchik. Good job. Anybody else on the list? This is it? Okay, we're done. Thank you, everybody. Have a good day.